And that would be for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. Good morning. You are Brandell Griffin?
Yes, ma'am.
And Mr. Griffin, in cause number 24 DCCR 1666, you're charged with the state jail felony offense of publishing or threatening to publish intimate visual material from June 24th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine and follow all of the rules and conditions of probation. You have every right to reject that offer. I just want to make sure you understand what the possible consequences are and what your options are. And do you want to reject that offer? All right, we'll get that case set on the trial docket. And Mr. Griffin, Mr. Rojas has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else. Is that okay with you? So, Mr. Rojas, you are released. Mr. Griffin, we will appoint someone today. If you'll have a seat on this side of the courtroom, watch for the clerk. She'll call you up in just a minute and let you know who your new attorney is.
Right.
Yes, sir. All right, sir. Again, you're Brandell Griffin?
Yes, ma'am.
And it's my understanding that you guys have come up with an agreement instead of going to trial. Is that correct?
Yes, Judge.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Looks like we're going on a lesser, correct?
Yes, Your Honor. Attempted, which makes it Class A misdemeanor.
All right, let me get that pulled up. Okay. Okay. So, Mr. Griffin, in cause number 24, DCCR 1666, the state has elected to proceed on the lesser offense of a Class A misdemeanor, attempted publishing or threatened to publish intimate visual material from June 24th of 2024. How do you plead it?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
No.
And you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal. And it looks like the agreement is for 30 days in the Jefferson County Jail that y'all have checked, and you have credit for 14 already.
Correct.
And the agreement is for me to reset sentencing to a different date so that you have time to kind of get your affairs in order so that you can go serve that time out. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Griffin is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to the 22nd. The 22nd, it's a Wednesday, so it's kind of a different day because of that week is kind of an off week. So we'll have docket at 9 o'clock that morning. It's very important that you're here, obviously on time, and also that you are not arrested for anything between now and when we come back, and we'll go forward with your sentencing at that time. And we do not need a pre-sentence report. All right, we'll see you back at sentencing. Thank you. Thank y'all for working that out.
Yes, sir.
Good morning. Are you Thomas Valentino?
Sure.
And Mr. Valentino was previously in court and entered a plea of guilty. Hold on, sorry. In count 1 only of the indictment to the state jail felony offense of theft of material. We reset the case for sentencing to give Mr. Valentino some time to get his affairs in order. And Mr. Valentino, just a couple questions. Have you been arrested for anything since we were here last
No,
time?
Your Honor.
All right. Is there any reason not to go forward with sentencing, Mr. Rojas?
No, Your Honor.
Ms. Malfino?
No, Your Honor.
All right, then, at this time, sir, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You will receive credit.
Wasn't the agreement 16 months, Judge?
Not 18.
Hold on, she'll pull up the paperwork.
I thought it was 16.
18.
On the plea agreement that y'all signed, everybody signed.
Okay. Can I have a moment? with
Sure.
Mr. Valentino?
Yeah, because that's the plea.
That is the plea papers, but okay.
Okay, I'll hold it for just a minute. Y'all just stay here in the courtroom, please. Mr. Rojas, are y'all ready on Mr. Valentino?
Yes, Your Honor.
Oh, yes, I will. Just so you know.
So have I.
11 and a half years.
Okay, so you're Thomas Valentino. Did y'all have an opportunity to visit Mr. Rojas about the paperwork and I guess
Yes, ma'am, it was a miscommunication, but both of us, I actually wrote 16 months. He remembered signing 16 months, but we obviously made a mistake. Paperwork says 18. If the court remember, he has credit for enough credit to cover the 18 months either way.
Okay.
And so we just want to make sure that we were both okay with the 18 months.
Okay. Any other issues? All right, then, Mr. Valentino, I'm going to find that you previously entered your plea of guilty freely and voluntarily. At this time, find sufficient evidence to find you guilty, and in clause number 25, DCCR 0121, find you guilty of the state jail felony offense of theft of material. Sentence you in accordance with that agreement to a term of 18 months in the state jail prison. You do receive credit for any time that you were in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back to the bailiff.
And Judge, if I could just for Mr. Valentino's benefit, the last time we were here, we checked his credit. He has 655 days credit. It wasn't attached to this case because he didn't have a hold on him, but the court had agreed to give him credit for that last time we were here.
What was it on? What was he sitting on? I remember talking about that.
It
was
Straight from us. And never left custody.
Yes.
right.
Yeah, so
So I gave him credit from the day that he was arrested on our case because you never got out. Correct. Okay, you'll get all that credit. We'll take care of
May I
it.
ask you also, Your Honor, would you be able to, would the court be able to
See, he's asking if there's anything the court can do to make sure he knows he's going to have to sit for some period of time until the state jail gives him the okay to be released. He's wondering if there's anything the court can do to speed up that process.
My clerk is very efficient, so we'll have your judgment done within a day or two max. And so the jail will have it this afternoon or tomorrow, and then it's up to state jail to get back to them and get you, I guess, your number and hopefully get you out from there. But that'll be all up to them.
But you got all the credit, right?
You have all the credit. Yes, sir.
It was 655.
Yes, sir. From the date of the arrest, because you never got out, we're giving you credit for all of that.
Thank you.
Yes, sir. Take care.
Mr. Griffin?
Good morning, ma'am. Are you Kelly McBride? And Ms. McBride was previously in court in clause number 25 DCCR 0044, entered a plea of guilty to the third degree felony offense of obstruction or retaliation. I've received that pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
Your Honor, there's no corrections that we want to address because of the circumstances around it. We are agreeing and we'd like to move forward.
Any issues?
No, Judge, just to let the court know, she also will enter a plea of guilty to the
That was part
Right.
of our plea bargain, so
Okay.
after the court sentences her, you're not following this, she'll go down the hall and enter back. With all of those conditions to be imposed as well.
Thank you. And is that your understanding as well? Y'all will go down and take care of that today?
Yes, Your
All
Honor.
right, then, Ms. McBride, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would have a felony conviction, and you could go to prison anywhere in that punishment range between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
Excuse me, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, before y'all go down there, probation will go over your paperwork, and then y'all can go down there, and if you think it'll be a little bit, they can go take care of that and come back.
You can come on.
Okay, she's gonna take care of you before y'all go down there.
Now I'm going to take care of Mr. Coker.
Perfect, thank you, sir.
Thank you.
I'll hold it for that.
Your Honor.
Good morning, you're Darius Sparks?
Yes, ma'am.
And Mr. Sparks is charged in cause number 25 VCCR 0754 with a third-degree felony offense of assault, family violence by impeding breath or circulation. And what is the announcement?
Judge, I believe we're asking for a recess so that Ms. Malfino can send a letter to the complaining witness and get her input on a possible offer of the
Sure.
deposition.
That's true, Judge. I have not heard from her since the original correspondence back in June of 25. If the
Okay.
court would allow me just a short period to send another one. We do have an alternative resolution.
All right, we'll just do a normal reset. Mr. Sparks, may make sure you stay in touch with Mr. Rojas and your bondsman. They'll let you know when you need to be back.
Thank you, Judge.
All right, you're free to go.